because a stage should come when you listen to others. So I'm not planned to be here to speak. I'll make 3-4 quick points. I wonder how many of you have heard the name of Sudha Bhardwaj. Today we are raising the name of one of our colleagues. Sudha Bhardwaj is a Harvard scholar who left the comforts of USA, came to India, worked in Chhattisgarh. She is behind the bars for a long time in Bhima Koregaon case. There is no resolution here of it passed. That is the secret of this whole issue. What I want to tell you is, this is not an isolated local battle. We must know. This is my first submission. Kindly understand the loss of civil liberties, the depreciation of democracy, the courts losing their power both because of the executive pressure and because of their own weaknesses is something we must not shut our eyes anymore. Therefore, one thing is that there is a larger phenomena which will create challenges for us, because when democracy declines, court in the first place, which should stop working or become very slow and not do its duty. Journalism the second, authors are the third, artists are the fourth. So first thing is, as lawyers, please start thinking that there is a larger challenge in the society to democratic values, to liberties. And when you have this challenge, you also have the challenge to the access to justice. So we have been, as I said, taking it as an isolated case. Two, do not individualize the case of Shelly Sharma at all. There were 4 lawyers involved, as you know. If ever there was a cause to feel agitated, there was a cause. And don't go into the question what he is charging, that will be derailing the issue. Don't go into the cases who the clients were. My friends there said, I'll be getting telephone from the smugglers. The beauty of this profession is we are duty bound to defend a person who would normally be scoffed at. A common man would say, why are you defending him? And we feel everybody's right to access to justice has to be protected. So, one thing on which I would compliment you is for taking up the issue. It is not an issue which is trivial, and don't trivialize it. It's a very important issue. Third thing is a clarification. The president was here. My young friends came to me once or twice for a petition. I said, do not make this case the core of the petition. You see, suppose a lawyer has been arrested, he has been ousted from his house, he has been beaten by the police. It is an individual case. This is not an individual case, and since we are going to the rights of the advocate to practice his profession, which in other words would mean the right of the citizen to be defended by a lawyer. Because if the lawyer is not free, if he cannot do his duty, all remedies are gone. So therefore, the writ which we are planning, kindly don't be under any misunderstanding. In this court, that writ will lie in the cold storage for 10 years. That writ has to be planned in Article 32. This case provides an illustration. So when my friends came to me, I said, please don't make a writ on these short grounds like we do. This happened without justification, the house was raided, so many hours were done. The issue would be on the privileged communication, Article Section 124, between the lawyer and his client. Also the right of a client to approach the lawyer. Also the insulation of this communication between them. And most important of all, the right of the citizen to access of justice. So when my friends approached me, I said, no, don't have this, have a comprehensive petition. And I now believe this petition has to be not here, it has to be in the Supreme Court. It has to be under Article 32. And there are now dozens of examples all over the country. This is not an isolated case. The first person was a lawyer in Nagpur who was rounded up, who is in ED, he is in custody for a long time. You probably have not also been following. There are today 5 acts where there is no bail. We all remember NDPS and twin conditions. But that is going to also act where the sentences are only 7 to 10 years. ED is one. Now it is in drugs and cosmetics also. So the encroachment, but then the next cause or the next fact which should cause of concern is how many important issues are pending in the Supreme Court and not decided. Start from electoral bonds, go to Article 370, go to demonetization. So there is no miracle which you can expect by filing a petition. Be very clear. Now the present petition which was filed, with respect to the President, I was not aware. I was not, when it was drafted or filed, I didn't know the contents. In fact, I wasn't there. The President called me and he told me that he wanted to come to me. I was away to Delhi from 30th and returned later. So I didn't know the contents, but yesterday and when it was taken up, I thought it is my duty to. No, I know that. I'm just saying this particular petition was not only an idea which I would conceive, it is an idea which I would have approved. It was an individual member's decision, and bar or the bar council were not behind it. But the only clarification I'm giving is I did not know the context. I was asked by somebody, I said, no, I don't know this petition, and I also don't think this will serve a purpose. But what happened yesterday, let me tell you. I was at the court. The stand of the NIA is that the case in which these raids were conducted was registered in August this year. These raids were conducted at 4 lawyers. Then they say that these properties have been submitted in the court of law, they are case properties. And what was not said specifically was, but I think is clear, that in so far our colleague here in the High Court is concerned, they found nothing incriminating against him. That is why the offer made was that when the petition will be filed in the court, the telephone would be returned. Which is another way of saying that no incriminating material has come against her on record. Now, this would again be a matter of principle. On suspicion, you have taken the phone here is of the lawyer, therefore the larger issues would come. But what was embarrassing in the court was, the court asked that you are asking us for a solution to the problem of strike. Your strike is legal or illegal. And it has been narrated before you. Then I'll come to the last issue. I've always been, this is a contradiction about me. Whenever this house gathered for a strike, I was a reluctant dissenter. I always believe every day we go to strike, somebody goes behind the bar, somebody's bail application is adjourned for 4 months, somebody doesn't get anticipatory bail, he is put behind the bar, somebody is dispossessed of his house, and it is usually the poor man who suffers. But at the same time, I would not take the stand that a bar should never refrain from work. Extraordinary situations arise, they call for extraordinary remedies, extraordinary reactions also. For you of this issue, I would not guide you. I think you are younger, you can look to it. What you will decide, you will go by the decision of the House. But what I would request you to keep in mind is, you are in the election mode, not the members, but there are the elections around the corner. When you take these decisions, please have all the dimensions of the case before you. And before I part, my last suggestion is, let us not complicate the case in which our young friend has been, her house has been written. If suppose on Monday, the report comes, and the report says that the status report shows, as I am saying from the oral government, that there is no complicity, there is nothing criminal against her. Let us be ready to consider that part of it. Let us separate the two files. One is on the basic right of the as not dependent of his constitution, legal statutory rights. That has to be kept. That is the with respect to this particular case, it sparked off the debate. So I can only advise, I'm old for that. My issue is have a kindly do review what you have decided and then take a decision with a cool mind. About the writ, as my friends have said, if we have to go, the writ has to be comprehensive, has to be in consultation with. My friends honored me by saying that I am the last word. No, we should go to council at the national level because we've got an issue which is very important. That is one part. Keep that alive. That is separate and let us follow it to the committee. The strike is the second part. And while you are on this suspension of birth, let us not be so bold so as to say that we don't bother what happened. Even when the judges put long dates in bails, we are paid because it is our client's pain we bother. The beauty about our profession is your client comes, he is depressed, he is a worried man, and you say, to fikr man. You buy his anxiety, you buy his pain. That is why lawyers have all those problems with their health. And that is the most glorious part of the profession. I feel the pain of the citizen. I feel so therefore, kindly continue to review whether it is working overall against the administration of justice, against justice going to the people. So 3 days, 4 days, 5 days, every day, this has to be looked. Next, which I must write today tell you, don't ignore the fact that the matters are not being taken up, not being discussed in the court. Adverse orders are not being passed. So that's one part again on which give all the cooperation to the executive. So it is not something we say, पूछ का सवाल है, demand का सवाल है. We are lawyers. We must always keep our brain in the right place. We must look at the issue, look at it again and again, take decision, review it, and then firmly follow it. And my last word is, we are with the house. I've got all the respect for my colleagues all these years. I'm fortunate to be a part of this bar. So therefore, everybody will honor the verdict that the house takes. I'm grateful.